Hello and welcome back.
Hey, great to be here.
You are listening to the WeCyberYou Unlocked podcast, and I am so glad you're joining us today for this deep dive.
Yeah, we've got a really interesting one today.
We do. We have a topic on the table that, at first glance, I admit, it might sound like a total cure for insomnia. It's a piece of legislation.
A very long piece of legislation.
Right. But stick with us here, because what we're actually looking at, pulling straight from the official text and explanations, is basically the ultimate rule book for your secrets.
It really is. It's the framework that decides who gets to know what about you.
Exactly.
And more importantly, what they're actually allowed to do with that information once they have it.
So today, our mission for this deep dive is to unpack the UK Data Protection Act 2018, or, the DPA 2018 for short.
Right.
We want to demystify this massive document. We're going to impartially distill the sources to figure out not just what the rules are, but why they actually matter to you.
Because they do matter to you.
Huge impact, whether you're running a massive business or just existing as a human being walking around with a smartphone.
And that distinction is vital right out of the gate. I think a lot of people hear data protection and their eyes just sort of glaze over.
Oh, completely.
Or they think, oh, you just mean GDPR.
Right, the cookie banners.
Yeah, but the DPA 2018 is very specific. It's the national law governing the UK. It dictates how personal data is collected, used, stored, and protected within the United Kingdom specifically.
And before we really get into the weeds of how that works, I want to quickly remind everyone listening, if you love getting these kinds of deep dive insights and you want to stay ahead of the curve, make sure you follow this channel.
Definitely.
And head over to WeCyberYou.com. That is WeCyberYou.com for more educational cybersecurity content just like this. It is a total goldmine over there.
It's an amazing resource for this kind of stuff.
Okay, so let's unpack this. You mentioned GDPR a second ago. I feel like we have to address the elephant in the room.
Let's do it.
If we have the GDPR, that massive European regulation that gave us all those accept cookies pop-ups, why on earth do we need the DPA 2018? I mean, are they the same thing?
That is the big question. And the short answer is no. They aren't the same.
Okay.
But they are best friends. Think of them as a dynamic duo.
Like a Batman and Robin situation.
Yeah. Or maybe more like a house and its foundation. The DPA 2018 works alongside the UK GDPR.
Got it.
You see, the UK GDPR sets out the main high-level data protection rules that we're all familiar with.
The broad stroke.
Right. But the DPA 2018 adds the UK-specific details. It handles the specific exemptions, the enforcement mechanisms, and it basically tailors those broad rules to fit perfectly into the UK legal system.
So it's almost like a customization pack for the UK.
That is a great way to put it. Especially following Brexit, the UK needed to ensure its laws were robust and specific to its own borders.
Right, that makes sense.
So while GDPR is the broad standard, the DPA 2018 is the legislation that actually implements and supplements those rules domestically. It's a dual system working together.
Okay, that clarifies a lot. It's not one or the other, it's both working in tandem. So now that we know what it is, let's talk about who actually has to worry about it.
Okay.
Is this just for the tech giants? Are we only talking about the Googles and Facebooks of the world here?
Not at all. And honestly, this is where a lot of smaller entities get caught out. The scope of this act is incredibly broad.
How broad?
Well, the DPA 2018 applies to organizations, government bodies, businesses, charities, and even schools. Basically, any entity that processes personal data about people in the UK is on the hook.
Wow. So charities and local schools, too. If you are handling data, you are involved.
Absolutely. The Act distinguishes between two key roles that are really important to understand. You have data controllers and data processors.
What's the difference between those two?
So the data controller is the entity that decides why and how the data is processed. They are the ones calling the shots.
Okay.
The data processor is the entity that actually does the processing on behalf of the controller. But the key takeaway is that both have legal responsibilities under the Act.
Got it. So if I run a business and I hire a third-party payroll company to pay my employees, I'm the controller because I decided to pay them.
Spot on.
And the payroll company is the processor.
That's exactly it. But here is what I find truly fascinating in the sources.
Yeah.
It's something a lot of modern businesses completely overlook. The DPA 2018 doesn't just apply to automated digital data.
Wait, what do you mean? Like not just computer files?
Correct. The text is very clear on this. It covers digital data, yes, but it also covers certain manual, paper-based records.
Kidding. physical paper.
Yes. If you have a filing cabinet organized in a way that allows you to easily find information about specific individuals.
Like an alphabetized set of personnel files.
Exactly. That filing cabinet is regulated just as strictly as a cloud server.
That is wild. I feel like we spend so much time in this industry talking about firewalls and encryption, but technically, a rusty filing cabinet in the basement could be a massive compliance nightmare.
It absolutely could be. It challenges that whole assumption that data protection is solely an IT issue.
Right.
It's an organizational issue. It's about the information itself, regardless of the format it lives in.
That is a huge realization. I think a lot of people just assume if it's offline, it's invisible to the law.
Definitely a dangerous assumption.
Okay, so we know who is involved. Now let's look at the what. The Act talks a lot about personal data. Now, I think we all have a vague idea of what that means, names, emails, that kind of thing. But how does the DPA 2018 actually define it?
The definition is quite specific. Personal data includes any information that can identify a living individual.
A living individual. So ghosts are exempt from the DPA 2018. Good to know.
Safe from the ICO, yes. The deceased are not covered by this specific act, but for the living, it's very broad.
So beyond names and emails.
Yes, obviously you have the direct identifiers, names, home addresses, email addresses, but it goes deeper. It includes identification numbers and, crucially, online identifiers.
Like what kind of online identifiers?
IP addresses and cookies.
See, I think people forget that. An IP address feels like machine data to most people.
Right. It feels anonymous.
But because it can be traced back to a specific person's connection, it counts as personal data.
Exactly. And the Act also covers media, photos, videos, voice recordings. If you can identify a person from a piece of media, it's personal data.
Wow.
It even extends to behavioral data and location data. Where you go with your phone, what you click on online, that is all your personal data.
So it's basically anything that acts as a digital fingerprint.
Yes.
But I noticed in the source text there's a tier above this, something called special category data. What is that about?
This is a really critical concept to grasp. The Act recognizes that not all data is created equal.
Right, some things are just more private.
Exactly. Some information is inherently more sensitive. So special category data is a specific classification for information that needs extra protection.
What falls into that bucket?
It's a strict list. It includes health and genetic data and biometric data, so things like your fingerprints or facial recognition scans.
Okay, that makes total sense.
But it also covers race or ethnic origin, religious or philosophical beliefs, sexual orientation, and trade union membership.
Trade union membership. That's really interesting that it's sitting right there alongside your genetic data and biometrics.
It is. But the logic, and this is the why that really matters here, is that misusing this specific type of data poses significantly higher risks to a person's fundamental rights and freedoms.
Oh, I see.
Think about it. If your email address leaks, it's a nuisance. You get more spam.
Yeah, annoying but manageable.
But if your medical records or your political beliefs leak, that could lead to discrimination, loss of reputation, or even personal safety issues.
Right. It's the difference between spam mail and potentially getting fired or persecuted. That makes a lot of sense why the rules are stricter there.
Absolutely.
So we have the players and we have the types of data. Let's talk about the rules of the game. The sources outline what they call the principles, basically the pillars of the Act.
Yes, these are the commandments, if you will, the core rules you have to follow.
Let's run through the big ones. The first one listed is lawful processing.
Right. This is the starting line. You cannot process personal data just because you want to.
Okay.
You must do it lawfully, fairly, and transparently, meaning you need a valid legal basis to even collect it.
So I can't just collect people's birthdays on my website because I might want to send them a discount code someday.
Not unless they've explicitly consented to that, no.
No.
You need a basis like consent or a contract, meaning you actually need the data to fulfill a service you sold them or a legal obligation.
So no data hoarding.
Right. You can't just hoard data just in case you find a use for it later. And transparency is key here, too.
Yeah.
You have to clearly tell people what you're doing with their information.
No secret data hoarding. That seems more than fair. The second pillar is about individual rights. This feels like the part where the power really shifts back to the little guy.
It really does. The DPA 2018 grants individuals some very strong rights. It transforms you from just being a passive subject of data collection into an active participant who has control.
What are the greatest hits of these rights? What can people actually do?
Well, the most fundamental one is the right to access. You have the right to ask any organization, hey, what do you know about me?
And they have to answer.
They absolutely have to tell you. They have to provide a copy of the data.
That's the subject access request, right?
That's the one. Then you have the right to rectification. If they have your information wrong, you can legally force them to fix it.
I like that. My name isn't spelled with a Z. Update your database immediately.
Simple, but legally binding. Then there's the really famous one, the right to erasure, which is widely known as the right to be forgotten.
Oh, yeah, I've heard of this.
Under certain circumstances, you can demand that an organization delete your data entirely from their systems.
That is a powerful one. I feel like that's one everyone talks about in the news. But surely there are limits, right?
There are.
Like, I can't just call my mortgage lender and say, hey, execute my right to be forgotten, wipe out my debt history.
Unfortunately for us all, no, that doesn't work. There are conditions. If the organization has a legal obligation to keep the data, like a bank needing to keep records for financial compliance, they can refuse the request.
Makes sense.
But if it's just marketing data they've been holding on to, you can absolutely demand they wipe it.
That distinction is so important to understand. It's a right, but it's not a magic wand to escape contracts. What about the other rights?
There's also the right to restrict or object to processing. This is basically you saying, look, you can keep my data, but stop using it for marketing or profiling.
Okay.
And finally, there is the right to data portability.
Portability, like moving your cell phone number to a new carrier.
Very similar concept. It allows you to take your personal data from one service provider and move it to another easily in a machine-readable format.
Oh, wow.
It prevents that lock-in effect where you feel like you can't leave a service because they're holding all your history hostage.
That is huge for consumer choice. It really does put the user in the driver's seat. Now, moving on to the third area mentioned in our sources, law enforcement. Does this act actually apply to the police?
It does, but with some very specific nuances. The DPA 2018 includes tailored rules for how police and law enforcement bodies handle personal data.
Right, because their needs are different.
Exactly. It's distinct from general commercial use because, obviously, they need to process data for the prevention and detection of crime. The rules are structured to allow them to do their job effectively while still protecting fundamental rights.
Right. You can't exactly ask a bank robber to sign a consent form to process their fingerprints.
No, that wouldn't work out very well at all. The police need to be able to act quickly. However, they are still bound by the core principles of accuracy and security.
So they still have rules.
Oh, definitely. They can't just keep data forever without a valid reason, and they have to ensure it's kept highly secure.
But speaking of exceptions and special rules, there's another area in the text that really caught my eye. The exemptions for journalism, research, and academic purposes. This seems like a very tricky balance to strike.
It is an incredibly delicate balance. This is where the DPA 2018 tries to reconcile the right to privacy with the right to freedom of expression.
Because they can conflict.
Yes. If privacy laws were absolute, investigative journalism would be effectively illegal. You couldn't write a news story exposing a corrupt official without getting their consent to process their data first.
Which would completely defeat the purpose of journalism.
Exactly. So there are built-in exemptions that allow data processing for journalism, as well as academic, scientific, and historical research, provided it's in the public interest.
I see.
It ensures that data protection doesn't inadvertently become a censorship tool.
I'm really glad that's in there. It feels like a very necessary safety valve for a functioning democratic society. And finally, the fifth pillar, the sources highlight children's data.
This one is increasingly important. The Act applies much stricter safeguards to children's personal data, especially when it comes to online services.
Because they're more vulnerable.
Right. The legal assumption is that children may not be as aware of the risks and the long-term consequences of sharing their data. So the law steps in to provide an extra layer of armor.
Which is so vital today in the age of TikTok and Roblox and constant online connectivity.
It is. And the UK has specifically rolled out the age-appropriate design code, which stems directly from these principles.
What does that do?
It basically says to tech companies, you shouldn't be using dark patterns or nudging kids to give up more data than they absolutely need to. You have to design your services with the best interests of the child in mind by default.
That is a fantastic standard to hold companies to.
Okay, so we have the rules laid out, but rules are really only as good as the enforcement behind them.
True.
What actually happens when things go wrong? Because, let's be honest, data breaches seem to be in the news cycle every single week. They do. And the DPA 2018 is very clear on this front. Organizations aren't just required to passively not leak data. They are proactively required to implement appropriate technical and organizational security measures.
So saying, oops, we got hacked isn't a valid excuse anymore.
Not if you left the digital front door wide open. You have to be able to prove to the regulator that you took security seriously before the breach happened.
I love that.
And if a breach does happen, there is a very strict reporting protocol that kicks in.
Who do they have to tell? Can they just keep it quiet?
Absolutely not. Serious breaches must be reported to the ICO, that's the Information Commissioner's Office, within 72 hours usually.
72 hours. Wow.
And if there's a high risk to the rights and freedoms of the individual, say passwords, credit card details, or medical records were stolen, the organization must notify the affected individuals directly.
So they can't just sweep it under the rug and hope nobody notices.
No. Transparency is mandatory. If a company tries to cover up a breach, the penalties they face can be significantly worse than the breach itself.
You mentioned the ICO. Let's talk about them for a second. They are essentially the sheriff in town for this act, right?
That is the perfect description. The Information Commissioner's Office is the independent regulatory body in the UK. They are the ones with the teeth to enforce this.
And how sharp are those teeth? Like, if a massive company just decides to ignore the DPA 2018 because it's inconvenient, what can the ICO actually do to them?
They have a whole range of tools at their disposal. They can issue formal warnings, they can issue enforcement notices demanding changes,
Okay.
and they can even order a company to stop processing data entirely.
Wait, really?
Yes. And for a modern digital business, an order to stop processing data essentially means stop operating your business.
Wow. Shutting down data processing is literally a death sentence for a tech company.
It is. It's the nuclear option. But if that's not enough to get their attention, there are the financial penalties.
Let's hear the numbers.
The fines can be astronomical. Under the UK GDPR and DPA 2018 framework, we are talking fines of up to £17.5 million, or 4% of the company's global annual turnover, whichever is higher.
4% of global turnover. For
Yeah.
a massive multinational tech giant, that could be billions of dollars.
That is the entire point. It's designed to be a deterrent that simply cannot be ignored as just a minor operating expense.
Right.
These aren't slap-on-the-wrist fines. They are business-ending numbers if the violation is egregious enough. It forces the board of directors to take data privacy just as seriously as they take their quarterly profit margins.
It really changes the whole calculus for these corporations. It's no longer just a cost of doing business. It is an existential risk to the company if they mishandle our data.
And that leads to the broader point of why this entire act matters so much. It aligns the UK with global standards, sure, but fundamentally it treats privacy as a fundamental legal right.
Yeah.
It's not just an IT checklist for the tech department. It's about trust. If we want a functioning, thriving digital economy, we need to trust that our digital lives aren't being exploited.
That is a brilliant way to frame it. It protects us in a society where almost every single thing we do leaves some kind of digital trace.
Think about it. Without this law, we would basically be operating in a Wild West scenario where your data goes to the highest bidder with zero oversight.
Terrifying.
The DPA 2018 provides the structure that allows the digital economy to actually function safely. It holds organizations accountable for data misuse and supports our trust in online services.
So what does this all mean for you, the listener? It means you have rights. It means your data is yours. And there are very powerful regulators in an office somewhere ready to fight for it if a company misuses it.
And it means that if you are running a business, you need to look at your data practices today. Not tomorrow, not next quarter, today.
Absolutely. We have covered so much ground here, from the specific definition of personal data all the way to those massive business-ending fines. The UK Data Protection Act 2018 is clearly a beast of a legislation, but a very necessary one.
It really is. And if I can leave the listener with one final thought, and this actually brings us all the way back to something we touched on earlier, think about that manual paper records rule.
Oh yeah, the filing cabinet. That one really stuck with me.
Right. In a world that is totally obsessed with cyber threats, firewalls, and AI hackers, I always wonder how many organizations are technically breaking the law right now. Not because of some highly sophisticated nation-state cyber attack, but simply because of a forgotten, unlocked filing cabinet sitting in a damp basement somewhere, full of sensitive customer records from 1995.
That is a terrifying thought to end on. The biggest danger might not be in the cloud at all. It might just be sitting in the storage closet down the hall.
It is definitely worth checking.
Definitely worth checking your basements, folks. Thank you so much for joining us on this deep dive. It has been a pleasure unpacking the DPA 2018 with you.
Thank you. It's such an important topic.
Before you go, please remember to hit that follow button on your podcast player. And do yourself a favor. Visit WeCyberYou.com. That is WeCyberYou.com. There is so much more educational cybersecurity content there waiting for you. Stay curious, stay secure, and we will catch you in the next deep dive.
Goodbye, everyone.